Yes, I'm lying down and no, I will not move to do this video. Okay, so I didn't see this. I don't check the docket on Saturday morning. Okay, so Fritz filed a letter in response. So Gottlieb had filed a follow-up letter on the from the hearing the other day about the subpoena to Friedman's law firm, and it actually looked like some concessions to me because he was sort of narrowing down even for remember there were 8 requests. 4 of them they said they don't have any, so there were only 4 left, and he was trying to narrow it down even further. But it looks like the timing matched up for Fritz, who this is the second time that he has been able to utilize a lively docket request to then share information with us, the public, that otherwise he would have no reason to do. He was able to say, here's my response to this argument that he's making. And oh, by the way, we had a deposition yesterday. And my guess is the whole deposition was, you can tell in the motion to seal that they said, just let's make the whole deposition confidential and then we'll piece by piece talk about whether stuff can be utilized. My guess is that what's under this redaction is that the only ongoing smear campaign about which she has personal knowledge involves the Wayfarer lawsuit against her and Brian Friedman's public statements calling her a liar. And, he attaches, it's sealed, but the portion of her deposition. That means they had real time, which does not surprise me at all. For the uninitiated, there's a court reporter in the room taking down everything that happens in a deposition, but it's in the code that court reporters use. Like if you looked at it and I looked at it, we wouldn't have any idea what the fuck it said. And then you say, okay, I'm going to order the transcript, and you can go back and they'll take usually a week or 2 or 3 and they'll get you the transcript. Or you can pay for something called real time, which is that it literally pops up on a computer screen in front of you as it's happening. And you use it in big high profile cases because you can actually use it while you're taking the deposition. And of course, that's what appears to have happened here. No surprise. But it allows him, these are the summary judgment arguments I was talking about. He's saying, listen, if the only smear campaign that's going on right now is us defending ourselves in a lawsuit and a lawyer talking about the lawsuit in public, there's no smear. And he brings up, this can't be an adverse employment action. These are all the arguments I thought they were going to make on summary judgment. So I think that they are previewing, don't give her these records because her theories for using these records to support either the ongoing retaliation or the defamation are going to fail as a matter of law anyway. And it allows him to make those arguments so that we can see that those are the next things they're going to argue when discovery is over. So you can see at the bottom of that paragraph there, they cite all this case law and say, in short, Lively's aggressively pursuing discovery for a defamation claim that will surely be dismissed upon a dispositive motion. A dispositive motion is a motion that ends that issue for the entire case. And there are 3 kinds of dispositive motions, and you better know them because I taught you about them yesterday. They are motions to dismiss, motions for judgment on the pleadings, and motions for summary judgment. So he's saying what I've been talking about, which is, we're going to move to get rid of this defamation claim because this is all part of the job of representing a client, and that can't be the subject of a defamation claim. And oh, by the way, we're going to move to say that ongoing retaliation since the case was filed cannot be ongoing adverse employment action because we're just litigating our case. To me, this is a signal that that's exactly what they're going to do. For people who are frustrated, like, why don't they do it now? You can't, at least not on the summary judgment stuff. I still think they might file a motion to dismiss or for judgment on the pleadings about the defamation because they can do that now. But if you want to get summary judgment, which is probably what you'd have to do on the adverse employment action stuff, you have to wait until discovery is over, because go back and watch that video. And I'm going to do the second one later today or tomorrow if I get the chance. You can't file that kind of motion until discovery is over because the court has to know all the facts that are out there. So my guess is that, and then, they bring up this issue again, and this is where I think they're probably going to win. I think that the judge is going to say, I will allow them to get from you non-privileged documents showing the sources of information that caused Friedman to make the comments in the press, the 5 comments or 6 comments or whatever that are actually listed in the second amended complaint. But I'm not going to let you see just like every source for every comment he's ever made, because that's too much. That's my guess. But as I've said before, they need to get that defamation claim out of there to get all this stuff to go away. And, here we go. Like, once the deposition happens, which I'm still guessing that it's not over. I don't see how you do that deposition in 7 hours. We might start getting blips of it like this. Of, right now it's confidential, which I think that's actually smart, because you don't just want like everyone putting out competing pieces of it. But this is the Wayfarer people now starting to slowly let out what her answers have been. So as other discovery disputes happen, maybe we'll get more. So that's what I see.